We are back on Morning Line. Our guest with us this morning, Chris Johnson, attorney with Takis and McGinnis, talking your questions, comments about, elder law and the like. And, I think, Chris, we've seen a lot of folks in light of this pandemic, too, saying, you know what, I either need to update or I need to get my act together and write my will. It's a sad thing, but you recognize that people now are dying. And I'm just wondering if you've seen an increase to that degree or what you're hearing with regard to putting wills together right now in light of this pandemic.
We do. There's an increased emphasis in what we would affectionately refer to as getting your ducks in a row.
Yeah.
I think people have seen the serious nature of this and the catastrophic consequences of not taking this pandemic seriously, and realize that simple things such as having a will, having your powers of attorney, which I think are vitally important. I always say those are the most important documents you'll have while you're alive, because those are the ones that are going to affect you while you're living. If you're incapacitated, if you're in a state where you can't function, you can't take care of your own affairs, you need to have those powers of attorney in place, or else your family's going to court to get a conservatorship, which is a very difficult and trying process, not to mention it can be very expensive. And so, yes, we have people come in. We actually opened another service line called a fast track plan for people who wanted to get documents turned around very quickly and had very simple needs, new married couple, no kids, or new single person said, listen, I just want to make sure everything's squared away for my extended family if something happens to me. And we see a lot of that. We think it's important. I always tell everyone I see, everyone should have a will. Everyone should have their powers of attorney. Everyone should have a plan in place that they've put some thought into, because it's vitally important. And yes, we are definitely seeing an uptick.
Yeah, give me a little more about that hotline you set up, which I think is really a good idea to expedite stuff, and what someone maybe watching right now does if they've not done this before, they're not really familiar with it, but they're thinking, now I need to get my act together and do a will. What are the things they need to think about before they call you, and then what information are you going to need to be able to put it together for them? I know this is basic stuff, but you know as well as I do how many people don't even have wills right now.
That's right. We joke it's basic stuff to us, but for most people it's a big deal. I mean, to think about, these are gravity questions. I mean, they really are. People think about these and it's very heavy topic to talk about. What's going to happen stuff after I pass? Who's going to take care of me if I can't take care of myself? And sometimes I use the old phrase paralysis by analysis. People really get hung up on some of those questions. And what I try and tell people is, listen, a 70 or 80% plan now is better than a 100% plan 3 or 4 years from now. And so we want to get something in place. You can always reflect on it, and you can always come back and amend it and polish things up anywhere you go. But the things that I want any client thinking about before they come in, I want them to think long and hard about who's going to be in charge if they can't be in charge. And I always say there's 2 great criteria. They have to have integrity, and they have to be good at math. For your durable general power of attorney, I want them for your healthcare power of attorney to be personal representative in your will, or what a lot of people commonly refer to as the executor or executrix. If you're going to go with a trust-based plan, you're going to want to talk about who your trustee is, who your successor trustees are. Those key players are vitally important, and we take for granted. I'm married, my wife, key player for me. She's my powers of attorney. She'll be the personal representative, and that's kind of baked into the cake with married couples. But for single people, it can get more difficult on who it is. And for some elderly, their kids are great choices, but some don't have children, or some have children that they're estranged from. And so they really need to put some thought into that. And then the second thing I want people to think about is, after you pass, what do you want to have happen to your stuff? And I think people sometimes come in looking for the answer. Well, Chris, what do you think? And I tell them, I say, listen, I can give you some ideas, but at the end of the day, this is your stuff. I'm not the one who worked a lifetime for this. You are. And I think it's vitally important that you get to decide where your stuff goes, who it goes to, in the manner that it transfers to them, so that it does the good that you want it to do in this world after you pass. And for some people, that can be a real difficult question. Do they want to give it to children? Do they want to give it to a charity? Do they want to give it to extended family members? The permutations are literally infinite. And those are good things to think about before you come into the meeting, because if nothing else, even if you're not 100% there, it helps facilitate the dialogue.
Can you put together a will, and I'm guessing you could put together a pretty ironclad one, couldn't you, Chris, that I guess anyone can challenge anything, but if you do a will right, and there are some disgruntled folks that are maybe left out of the inheritance and they want to challenge it, if you do it right, does that pretty much shut down any challenges?
Yes, and so there are two things about that. I love that question. I get it, fairly significantly. Did I lose you?
No, I got you. I got you. You're good.
I'm sorry, Nick. My screen blanked out there for a second. So the favorite thing I love about that question is this: there are two things that you can do. One is you can put in interim clauses, which literally is to terrorize the people who would come to challenge. And those clauses basically mean, and it comes from Latin, and what it's saying is, if you challenge this will, you are going to lose whatever you had in this will. So if someone thinks they didn't get enough and wants to challenge it, and an interim clause, they lose everything. And that's a good way to dissuade it.
Interesting.
The best way to dissuade it is a just properly drafted and executed documents. You know, what do they say? What makes a good football team? Good blocking, good tackling. Well, it's the same thing in the law. If you just execute your wills in accordance with the law, execute your documents, your trust in accordance with the provisions of the law, you're going to be fine. I share it with my clients all the time, because I get this request all the time. Chris, I want to make sure that no one can challenge this will. And I said, listen, that's like you going to your alarm company and saying, hey, alarm company, I don't want anyone to ever break into my house. Well, they can't stop people from trying, but what they can do is stop people from being successful. And that's what we want to do with our documents. I can't stop someone from trying to challenge it, but I can stop them from being successful.
And it seems like if you do everything right the way you just described, that makes sense to me. I just think back to the famous Anna Nicole Smith case, where she married that older bazillionaire, and when he passed away, he left much of the money, and the paperwork was in place. How do you go about addressing not only dotting the I's and crossing the T's, but also making a convincing representation in the will that the person who put it together was of sound mind when they did? Because that sometimes thinks, well, everything looks normal here, but you know what? He was out of his head when he signed it. How do you protect against that?
That's always the most difficult thing, and it's going to be proven by circumstantial evidence, going to be proven by people who were around him at that time. And so what I would want to do is document the things that show his mental capacity and show that he had full control of his faculties. And that's the biggest thing. And that's keep anything from keeping contemporaneous notes to make a video recording to show that they have capacity and they know what's going on. All of those little things. And that's why on the will, we require 2 witnesses to sign. We want those witnesses to sign that will and say, hey, we were there. He or she knew what was going on. And so you just do your best to document if there's any question. Now, you know, with most of us, there's going to be no question. If I sign a will tomorrow, I don't think anyone's going to make a big valid charge on capacity in the same view. But if you think it's a question, the more you think it might be a question, the more it's wise to document the circumstances.
Yeah, it makes sense. And I think you just hit it on the head there. You anticipate it. And if you think, and usually it's probably with huge estates, maybe millions of dollars at stake, and maybe a dysfunctional family. If you see that coming, you can take the steps, as you just said, videotape it, have witnesses. So if they challenge the mental state, you have an abundance of evidence to prove otherwise. It's fascinating. It really is. Listen, we'll take a break. When we come back, we've got more phone calls. Tracy and others, if you're on hold, stay there. We'll get to your calls for Chris right after this.